Whether you have an employment, criminal, family, corporate, or personal injury matter, legal issues can be puzzling. The lawyers at Devry Smith Frank make all the pieces fit together.
Good morning, everybody. My name is Justin Winch. I'm a 7th-year lawyer, and I've been at DSF for the last 2 years. I'm here to talk to you today about fixed severance entitlements and whether or not the employee has a duty to mitigate their damages under these circumstances. And while this may not be the most exciting topic, a recent case from the Ontario Court of Appeal, known as the Bose decision, has really altered the landscape when it comes to the duty to mitigate under employment contract damages. And it can have a significant impact on employers who use employment contracts in determining how much they must pay terminated employees. I know Megan asked you earlier how many of you have employment contracts. I'm wondering how many in those contracts, how many of you specify what the employee's damages are once they are terminated. Does anybody know? A few of you know. Oftentimes there'll be a fixed amount, say 3 months, 6 months, whatever it is. But this recent decision may cause you some headaches which you didn't anticipate. In fact, it could be a lurking issue that you may not know about. And hopefully I'll give you a little bit of clarification today. So background. Just a little bit of background before we jump into the recent Court of Appeal decision. As you probably are aware, employees who are terminated without cause are entitled to receive reasonable notice of their termination or pay in lieu of. Now, reasonable notice can be based on a variety of things: the employee's age, their years of service, their position within the company, their level of education, as well as their availability of similar employment once they leave the company. Other factors which may be considered as well is whether or not that employee was induced to join the company. Really, the courts say there's no laundry list of factors. It really is a gray area, and each case is different. Now, before the recent decision, it was one of those things in law that were simply known. The employee had a duty to mitigate their damages. This duty obligated the employees to seek out and accept reasonable alternate employment and allow the employer to reduce its obligation. Therefore, if a reasonable notice period was, for instance, 6 months, and after 2 months of searching the employee found a new job, the employer could essentially claw back the payments that were owed to the employee by the amounts that the employee had now found. And the reason why this was done was because severance is not a reward. It's simply, you've been working here for 10 years, thank you very much, here's your bonus for those 10 years. That's not what severance is. Severance is a stepping stone or a bridge which gets you from one job to the next. It's essentially a safety net that the law says is important to make sure that people who fall out of the workforce are able to get back up on their feet. Now, the duty to mitigate applied both to common law dismissal damages, where the employment contract didn't specify the amount, as well as to those payments fixed by any employment contracts. And the reason why employers would often specify the amount of damages within a contract, or the severance amount within a contract, was simply to avoid the uncertainty. If you spell it out in a contract, you know if you're letting this person go, what's the check that you're going to have to write? How much is this going to cost you? Otherwise, if you get involved in common law damages and you're going through possibly a lengthy court battle, you're leaving that up to a judge who's going to take a look at everything, and he's going to give that employee some sort of award. And in a lot of cases, as an employer, you're not going to like what the judge has to say. So this is the case I was referring to. It's Bose versus Goss Power Products, Inc. And Mr. Bose, he was terminated from his employer without cause. He had an employment contract which spelled out exactly what he was to receive upon termination. And that was 6 months' pay in lieu of notice. 2 weeks after his termination, Mr. Bose found new employment. At at pretty much the exact same salary. As a result, his former employer, Goss Power Products, ceased making any payments to him. They were relying on the old standard duty to mitigate. He shouldn't double up in his earnings. Why should we be paying him at the same time his new employer is also giving him the same salary? The Ontario Court of Appeal disagreed with the employer's reasoning, and in the process they significantly changed the obligation of an employee to mitigate his or her losses when termination entitlements are fixed by an employment contract. The court made 3 significant findings. An employee does not have a duty to mitigate his or her losses where the employee's entitlement to notice of termination or pay in lieu of is set out in the employment contract. Furthermore, an employer cannot reduce the amount of notice of termination owed to the employee even where the employee finds new employment during the contractually agreed upon notice period. Finally, an employment agreement must clearly specify that the duty to mitigate applies if an employer wants the employee to be subject to the duty to mitigate. Therefore, the court held that by fixing a contractual notice period in the employment agreement, employers and employees opt out of paying common law reasonable notice. In doing so, they're avoiding the uncertainty, but at the same time, because they're opting out of the common law damages, they're essentially locking into what's in the contract. So if the contract is silent in regards to the duty to mitigate, well then you can't hold the employee to a standard that they didn't agree to. So essentially what this all boils down to is that if the employment contract specifically does not call on the employee to mitigate his damages, then there is no duty. That duty simply does not exist. Now the court went on a little bit here, and they talked about why this is fair. And they distinguished contractual payments owed on termination versus those common law damages. So in the Bose decision, it was interesting because his contract entitled him only to his salary and car allowance, nothing else. That's simply what the employment contract said. But if that employment contract didn't exist, Mr. Bose would have been entitled to something different. Not only would it include his salary and car allowance, it would also include any bonus amounts, other monetary benefits, as well as certain disability benefits, short-term sick leave, all of those items which were left out of the employment contract. So noting the difference between the calculation of common law damages and those that were found within the employment contract, the court found that it was entirely appropriate that mitigation should apply to one method of calculating damage for the loss of employment, which were the common law, but not the other contractual entitlements. And the court noted that the employer was in fact only paying Mr. Bose once, and that essentially that Mr. Bose was receiving is his contractual severance was significantly less than he would have been receiving under the common law. And to give the employer the benefit of contracting out of common law damages, while at the same time forcing an employee to live up to standards that were not set within that employment contract, was simply not fair to the employee. Here's the quote from the Court of Appeal, and it's interesting. In my view, the justice said, "There is nothing unfair about requiring employers to be explicit if they intend to require an employee to mitigate what would otherwise be fixed or liquidated damages. In fact, what is unfair is for an employer to agree upon a fixed amount of damages and then later on inform the employee that future earnings will be deducted from that fixed amount." Essentially, you can't contract out of your own contract. And the Bose decision, it did significantly alter the landscape that employers are facing. Before that decision reached the Court of Appeal, the Superior Court of Justice in Ontario had agreed with the employer. It was a long-held belief that the duty to mitigate exists in all areas, whether there's a contract or no contract. But the Court of Appeal, in its 2012 decision, said That's simply not fair. So what do you as employers need to consider going forward as a result of this Bose decision? Well, the first thing to consider is that courts will strictly interpret employment agreements. And when they interpret it, because it's the employers who are doing the drafting of these contracts, they're going to usually find in favor of the employee. If there's any ambiguity, if there's something that's left unsaid, typically they're going to side with the employee. So employers who use employment contracts that set out fixed notice periods or payments on with-it cause terminations, you should all carefully review what's in those contracts. If you go back and you look at it and you say, hey, we know we're okay, we have 6 months here, we know when we're terminating these employees exactly what we're going to pay, just make sure that there is a duty to mitigate in there, because if there's not, it could lead to some serious consequences down the road, and you'll certainly be paying out a lot more than you thought you might have to. And so if you're able to revise contracts, or when you're drafting new contracts going forward, be careful to include that the employee's right to notice or pay in lieu thereof is subject to the duty to mitigate, and that any earnings from the new employment may be used to reduce contractual payments owed. I would suggest to you that you may want to have your existing contracts or any new contracts reviewed by a lawyer to make sure that you're in compliance with the Bose decision. It would be very unfortunate that the uncertainty you were trying to get out of is now coming back to bite you. And really through no fault of your own, because the employment contracts and the terms thereof that would have been completely valid and enforceable prior to Bose, well, that's simply no longer the case. So it is important to review those and make sure that everything is good going forward. I think that's it for me, and if anybody has any questions, I'll be happy to speak to you shortly. Thank you.